vote,
Yes.
you can have as much a representation of the people,
Yes.
Registered voters as possible.
Yes, my lord.
Would that wise approach also be one that the IBC would do with regard to an important question like a referendum on the Constitution?
Oh yes, my lord, that's true. The only thing that we then need to ask ourselves is at what point does the IBC make that decision? We say that decision, my lord, can only come when the IBC is seized of the referendum. As we speak, the IBC is not seized of any referendum.
Thank you. So now, if you look at the declaration that you have a problem with, what do you say about that, about registration?
A declaration is hereby made that the Constitution of Kenya...
What page, sorry, what page of the...
That is, I think, at page 3 of the last declaration number 9. A declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration exercise.
Is that the same as mass, the mass thing you're talking about?
Not quite. Nationwide, it's always an ongoing process, because even now there's a nationwide registration of voters.
So do you have a problem with that declaration as it stands, that before you can have the referendum, because they're saying before the referendum,
yes,
before you can have the referendum, there should be a nationwide voter registration. Is that a problem?
Yes, my lord. It is a problem in this sense. It first presupposes, because it comes from a concern that was raised by the petitioners, that there is no voter registration going on. And my lord, it's not just about registration.
But if you actually are doing it, it means they are declaring that which is already happening. Why do you have a quarrel?
My lord, perhaps context is also important for this. Before the IEBC engages in any of these activities, what do? They get data from other institutions. National Registration Bureau, they ask them, how many people have you registered, for instance, in the last 6 months? So on account of those sort of statistics, they make informed decision that, oh, we think that there's been maybe about 500,000 more Kenyans that have been registered. Let's have a drive. Let's encourage. The more important question, though, is why don't we let the IBC be the ones to make that decision? Why do we want to look like we're getting into their position and telling them, we know you IBC, you may not register us after all. We want to have an order just in case. Why can't we allow them to do? In any case, my lord, when properly seized of the referendum, when the opportunity eventually comes, the IBC will look at this data and they'll say, we think perhaps it will be their decision. I'm not preempting that we now need to run mass voter registration. All that I'm saying is we need to give them that flexibility to make it their decision because of their independence. Thanks, my lord.
So Mr. Gumbo, what I was asking is this. Because you referred us to paragraph 769,
yes,
where the learned judges say that the IBC was not discharged its constitutional and statutory obligation to enable citizens, to do continual registration. You referred us to the paragraph 117 of Mr. Morara Omoke.
Yes, my lord.
Now, to enable the court reach an informed conclusion or finding as to whether the learned judges were right in the words they put in page 769, can you please show us the affidavit of Michael Goa where you said the contrary, so that we are able to place it in its context?
My lords, this is volume 5 of the record of appeal of...
So we will find it at volume
5.
Volume 5.
Page 2193.
2193.
At paragraph 10.
So that answers, in your view, the issue raised by the learned judges at paragraph 767, 769.
Yes, my lord.
Thank you.
Thank you very much, my lord. And more importantly, my lord, like I said, before the learned judges pose that question, the primary obligation on the part of the petitioners would have been to discharge that burden. My lords, would be looking at a situation where somebody says, and this I think is what learned senior counsel Professor Gidu Mugai was alluding to, we would want a situation where somebody says, I am a Kenyan, I approached the IEBC to register as a voter and I was denied that opportunity, or that there was a potential threat of me being denied that opportunity. Okay. In the absence of that, my lord, we cannot rely on what Mr. Morara Omoke says. He is apprehensive. An apprehension, my lords and my ladies, is not evidence. My lords and my ladies, perhaps
are you watching your time?
Yes, my lord, but I'm also praying that for the interventions, my lords and my ladies, perhaps there's equal attention to the time that runs off our plate.
Yeah, just before you move on.
Yes.
Now, you have said the onus was on Mr. Omarara to prove
yes.
the allegation. And at the same time, you are telling us this is specialized information that your client insists of. Don't you think that the farthest Mr. Omarara could go is to raise that issue? And then what for your client is simply to come forward and say, yes, you have raised this. As a Kenyan citizen, you are entitled to it. And here is what I have. What you are asking for is already in place. And I think that is what the judges were interrogating at the paragraph 769, what the president has brought to your attention.
Yes, my lady.
Yeah.
May I respond?
Please do.
So, my lady, it is okay to make such an inquiry, but must such an inquiry be made for the first instance in a court? That is the concern. Why don't you, as a responsible Kenyan, come in and say, wait, we think we may be running into an election. What are you people doing about this election? Is there a continuous registration of voters? Please get me a document to see that there's continuous registration of voters or there's none. It is not, in our view, okay to make a first port call, which reminds me of what I learned in the laws about injunction, something called quia timet injunction. You just say, Timeo, I fear. My lords, I think there is a greater obligation. There is a greater obligation on anybody who wants to confirm, and that, my lord, again, is information that is available out there. Every so often, and perhaps I'll just make reference to the affidavit of Michael Gore, again, filed on the 25th of June, 2021, at paragraph, that is... at paragraph 6, my lords and my ladies, attaching a gazette notice. My lords and my ladies, that gazette notice does one thing. Every so often, the Independent Electoral and Boundaries Commission, as a way of communicating to Kenyans, says that we have up to now gotten this number of registered voters. We have shared one of those gazette notices, so that then it is just confirmed, because it is a legal provision that it is that, my lords and my ladies, there is continuous registration of voters. My lords and my ladies, perhaps I would move then to the next part of my presentation on the question of public participation. Sorry, my lord. Thank you very much, my lord. So, on the question of public participation, specifically as to whether there is an obligation on the IEBC under Article 2574 to confirm that a promoter...
Mr. Goa, please permit me. I'm so sorry about this.
Yes.
You made reference to this gazette notice.
Yes.
Which is attached to Mr. Goa's affidavit.
Yes, madam. I
just confirm that this is gazette notice number 2934 of 16 September 2020.
Yes.
Right?
Yes, my lord.
Now look at it.
Yes, my lord.
It says you are certifying the completion of the revision of the register of voters as at what date?
This is as at 31st December 2019.
2019.
Yes, madam.
This is something that Mr. Goa filed here before us 2 days ago. Am I right?
Yes.
So you get an opportunity to indicate what you're doing with regard to continuous nationwide registration, and what you brought before us is an indication of registration as at 31st December 2019.
Yes, my lord.
Okay.
And permit me to explain why.
No, I just confirmed the date.
Yes, my lord, but it is important that I contextualize it.
All right.
The obligation, my lords and my ladies, that is done periodically. So that, again, towards the end of this year, there will be a similar gazette notice issued. It doesn't mean that there's no registration going on. It's only that it can't be issued weekly. You issue it maybe after 6 months, you issue it after 1 year.
Was there one indicating registration as at the end of 2020?
My lords, I maybe would want to just confirm that from the clients.
All right, thank you.
Yes, but my lord, the position, as I indicated, what was the evidence that was presented by the other side? Why do we want to shift the burden to say we allege, prove? We must start from somewhere for sure.
Thank you.
Most obliged, my lord. Then on the question of public participation, we look at paragraph 577. The learned judges of the Superior Court say that additionally, the IEBC was under an obligation to ensure that the BBI Steering Committee had complied with the requirements of public participation before determining it had met the constitutional requirements for transmittal to the county assemblies. What do we have to say about this, my lords and my ladies? Simple. Article 257(4) reads, shall verify that the initiative is supported by at least 1 million registered voters. Where do we get this obligation and impose it on the IEBC from that article? My lords and my ladies, I have tried to interrogate the submissions that have been presented, even by the respondents, on that question of public participation. The closest I've come to is submissions filed by a learned friend, Mr. Harvey, which says that that obligation is to be found in the writings of John Locke, Baron de Montesquieu, and Professor Ben Nabweze. This is found at paragraphs 36 and 38 of the submissions that have been filed. My lords and my ladies, I want to pose the question. Would it be open for the IEBC to reject a bill together with more than 1 million signatures presented on the question of public participation? Would they object without attracting or fomenting a cause of action against them as imposing a condition that the Constitution does not contemplate? My lords and my ladies, it should not be taken that the IEBC does not appreciate public participation. The question of public participation is so important under the heart of IEBC. The only thing that we are saying is that that public participation must be context specific. In relation to Article 257(4), my lords and my ladies, that obligation does not lie with the IEBC. We've seen, if we read the entire spectrum of Article 257, we have obligations to the county assemblies, the parliament, and the grand extravaganza itself if we ever get to the referendum. That is the ultimate public participation. IEBC would be ill-equipped to get to a point of saying that we are rejecting your initiative because you've not given us minutes of meetings that you had or any other demonstration of public participation, because the Constitution at that point in time does not impose the obligation on them. To the flip side, my lords and my ladies, that would be a very good ground for somebody to raise if at the end of the day or at the end of this process, somebody files an application under Section 80 to 88 of the Elections Act to file a referendum petition where somebody will be challenging the fact of there not having been sufficient public participation.
The learned judges were saying that IEBC was interpreting and applying the Constitution.
Yes, madam.
And therefore the values espoused under Article 10 kicked in. What do you have to say about that?
Yes, my lord. They kick in. But at what point? Who has the tools to measure that? At that point in time, the requirement for purposes of confirming public participation is a requirement that if you read, and this is about holistic reading of the Constitution again, if that obligation to make that confirmation that there was public participation is reposed expressly in another institution, then it would be inappropriate for IEBC to tell somebody that before you come to me, present me with three things. Get me a bill, get me 1 million registered voters, and also get me evidence that you had public participation. My lords and my ladies, that is stretching the meaning of the text of Article 257(4).
And I think we really had many interventions. But I understood, and maybe you could comment on this, I understood Senior Counsel Kambuni to say that in fact at the point when someone, and I don't want to use the word initiator, which you have a problem with, someone initiates the process under 257(1) and collecting the 1 million votes, there is no need for public participation. That in fact, you can look for people who share the same view, friendly people, as long as you get the 1 million votes. And that the issue of public participation is at the point the bill is then presented to the county assemblies. So, I mean, you could connect that. I don't know whether you have
Yes,
a
my lord.
comment.
Article 257(1) is the one that then introduces that threshold. And my lords, the obligation under Article 257(1) is reposed in the promoters, so that if today we sat with your lordships, ladyship, as members of the legal fraternity, we say that we have looked at this constitution and we've specifically looked at Article 163(3)(a), the jurisdiction of the Supreme Court to make a determination on a presidential petition. And we think these 14 days are too short for that court to do that, to do justice to that matter. We need to expand or get that period expanded. What does that mean? It is a well-founded proposal. What does the Constitution expect? We may sit here, we may be 100 people. If you go to the IEBC today, you tell them this proposal makes sense. You say, all right, it might make sense to you, but because this Constitution is a document that is shared by Kenyans, can we get at least 1 million of you who think the same way so that we can engage Kenyans? So essentially, it's more of a trigger. So that you say, we've gotten 1 million people who think that there's need to expand for the 14 days, please consider them. Then the other Kenyans will be asked, oh, there's a proposal to expand this period. We then open it up to a debate. We say the reason why we think there's need for this proposal, or rather for this amendment, is so that the court can have perhaps 30 days, so that there's not too much pressure on the court. It will now be upon the actors in that space, the various actors, to engage in public participation at that point in time. That is my understanding of that provision, my lord. My lord, my ladies, perhaps I would quickly then run to the last question about the referendum question. On this issue, my lords and my lady, paragraph 611 of the judgment, the learned judges of the Superior Court say, we have been asked to determine whether Article 257(10) requires all the specific required amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot. My lords and my ladies, the learned judges of the Superior Court then go on to make a finding, that is Declaration 18, that a declaration is hereby made that Article 257(10) of the Constitution requires all specific proposed amendments of the Constitution to be submitted as separate and distinct referendum questions to the people. My lords and my ladies, why do we, as the IEBC in particular, why are we aggrieved with that finding? One, I would want to ask the question, the learned judges of the Superior Court, they were invited. First principles, whenever you're invited to make a determination, you ask yourself, and this is the point that learned senior counsel Professor Githu Muigai was making, you must ask yourself whether you have the jurisdiction to make that determination. It is not just a question of saying a question was presented to us. Satisfy yourself. My lords and my ladies, we say that because in the absence of a controversy, you present such a question to the IEBC, then you are at best inviting them to exercise advisory jurisdiction, which they do not have. I then asked myself the question related to that. What was the controversy that was presented for the determination of the learned judges? My lords and my ladies, at the second paragraph after the learned judges, I think paragraph 612, the learned judges find a report. They say that the petitioners cited the final report of the Independent Commission on Referendums on this question from the University College of London. My lords and my ladies, how is this report to form a controversy that is being discussed in a court of law in Kenya? Let me leave that at that and say, my lords and my ladies, Section 49 of the Elections Act reposes the obligation to make a determination on a question touching on the referendum on the IEBC. In particular, 49.2 says, where an issue to be decided in a referendum has been referred to the commissioner under subsection 1, the commission shall frame the question or questions to be determined during the referendum. Now, with that as a background, I submitted earlier, the IEBC is yet to be seized of this referendum. They can only and will only be seized of this referendum if under Article 256(5)(a), His Excellency the President sends or triggers that jurisdiction. So before that arises, it is then our humble submission that it is premature to expect the IEBC to have engaged in that question. My lords and my ladies, it is our submission that that issue was not ripe for determination before the learned judges of the Superior Court. My lords and my ladies, again, it is important to note, and this is a point that learned senior counsel Professor Gidu made very well, the IEBC is an independent institution. They cannot be, and we cannot have a situation where what they're supposed to be doing is being discussed away from them and a direction given to them that you shall, at the point of dealing with the referendum question, do A, B, C, and D. My lords and my ladies, this, in our view, is an inappropriate application of the Constitution. And my lords and my ladies, I am not alone in saying that. A member of, a honorable member of the bench, Justice Fred Ochieng, in a case that we've referred to time and again throughout this decision, that is the decision in Titus Alila, and it's cited as one of the authorities that appears at page 230 of our bundle and digest of authorities, when faced with a similar question on the issue of referendum, had the following to say. At paragraph 57, Justice Ochieng says, Section 49 of the Elections Act gives to the IEBC the mandate to frame the question or questions to be determined through a referendum. At paragraph 59, the learned judge says, this court cannot purport to give the IEBC directions on exactly how to carry out its responsibility in that respect. The last paragraph, in a bold statement, it says, if the court were to give generalized directions to the IEBC when it had not been shown that the commission had started from a path not established by law, that would constitute a blatant interference by the judiciary in the constitutional mandate of an independent commission. My lords and my ladies, that decision was presented before the learned judges of the Superior Court. We have seen the declaration that they made. We leave it to you, my lords and my ladies, to make a determination. On my feet, my lords and my lady, I would want to make a plea that on that question, and it reminds me or takes me back to the to the question that Justice Gatemu Kairu asked. When faced with such a situation, would it not be right to have a setting where there is a harmonious way of facilitating institutions to work with what I would call clear directions from courts in terms of court judgments? My lords and my ladies, what am I saying? I'm saying it places independent institutions in very awkward positions when today there is a judgment that could come from Judge X in a place Y. Tomorrow, another decision touching on the same issue, constitutional interpretation, again from another judge. It leads to a situation where we will be forum shopping. My lords and my ladies, that is not the sort of practice that we want. In fact, as a practitioner of law, my lords and my ladies, I've been put in a place where sometimes it is difficult to even advise a client. You advise, you give a written opinion, but you must timestamp it. Why? Because if you don't timestamp it and issue a disclaimer that my opinion is valid up to the time I'm signing this decision, another contrary decision will come from somewhere. And my lords and my ladies, you'd be accused of having misled an institution. Our proposal, my lords and my ladies, is that when dealing with these sort of issues, particularly interpretation of a question of public law, it could be a constitutional interpretation. My lords, my ladies, you may want to give guidance in how then the court below you, the learned judges of the superior court, can apply or exercise their jurisdiction without creating hardship to the institutions that depend on them for guidance and interpretation. An example would be the Lady Justice Okwanyi says that IBC, you have jurisdiction. Please you have quorum, carry on with what you're doing. So they then go on to make arrangements, do this, do the other in relation to their institution. Shortly thereafter, they told, wait a minute, whatever you did in the hope that you had jurisdiction is actually null and void. What does that do to institutions that then are expected to apply the law? It then places them in a position where the man in Kangemi bus would start doubting the ability of these institutions to work the way they should work. So it is a really important question to ask. Let us have, my lords and my ladies, a Titus Alela moment. Let's have a guidance on this very pertinent issue. My lords and my ladies, with that, I think I'm only left with 15 minutes. Permit me to allow my learned friend, Mr. Moses Kipkogei, to address you on the other matters. I'm most obliged for your patience.
Thank you. Mr. Kipkogei, it looks like you have only 15 minutes.
My lord and my ladies.
Just state your name for record, and you may want to lift up, to raise the microphone.
My name is Moses Kipkogei. I join Attorney General Emeritus Professor Muigai and Mr. Gumbo in appearing for the IEBC. I will try my best in the remaining time.
Are you able to adjust the microphone so that it is kind of...
Yes. It's an issue to do with height, my lord. I should perhaps have had a longer podium. My lord, I will address my lord on 3 elements which arise from the decision of the Superior Court in relation to the declaratory reliefs which were granted by the court. And that relates, my lord, to declaration number 11, declaration number 12, and declaration number 17, which are contained at pages 71, 67 and 71, 68 of our bundle of our record of appeal. My lord, those 3 declarations relate to the legal regime applicable for purposes of conducting a referendum and the finding in relation to the administrative guidelines which were issued by the IEBC to govern the process. I note, my lord, that Malanet seniors who have addressed you ahead of me have touched on those, and I will try to touch on areas which they did not touch on. But before I do so, my Lord, allow me to address you on just one aspect which arose from Mr. Gumbo's submissions in relation to the interpretation to be accorded to Article 257, sub-Article 4. My Lord, the learned judges of the Superior Court expended quite some considerable effort in unpacking the phrase verification of signatures. My Lord, that phrase does not exist anywhere in the Constitution. What is in the Constitution, my Lord, is a phrase which reads as follows: verification, quote unquote, verification that the initiative is supported, and it continues. And it ends with voters. That was important, my Lord, to highlight because it is direct, it directly affects the process which was put in place by the IEBC, including the administrative guidelines which were published, which were issued by the Commission. My Lord, declaration number 11, my Lord, in that declaration, the Superior Court states as follows, that a declaration is made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. They repeat in somewhat similar language in declaration number 12. My Lord, allow me to address you on the last sentence or the last phrase of that declaration, nor a legal framework to govern the conduct of a referendum. My Lord, the Elections Act, in its long title, states as follows: that it's an act of Parliament to provide for the conduct of elections to the office of the President, the National Assembly, the Senate, the County Governor, the County Assembly, and to provide for the conduct of referenda. My Lord, we submit that the declaration by the Superior Court that there was no law governing the conduct of referenda was erroneous and without basis, because there is an act of Parliament which declares itself in its long title that it governs referenda, and it is the Elections Act. When you go through the Elections Act, my Lord, you will note that in relation to the Register of Voters, the Register of Voters applies to both elections to elective positions and referenda. In relation to accreditation of observers, Section 40, it applies, my Lord. There is a whole part 5 of the Elections Act, which is dedicated to referenda. There is a whole chapter dedicated to dispute resolution for referendum processes, running from Section 88, my Lord, to Section 103 of the Elections Act. The Electoral Code of Conduct, which is a schedule to the Elections Act, applies not only to elections, but also to referenda. The word referendum has been used in the Elections Act 167 times. My Lord, Election Offences Act applies not only to elections, but also to offences committed in the course of referenda. the Election Campaign Financing Act, my lord, also applies to referenda. How then did we end up with a finding by the Superior Court that there is no law governing the conduct of referenda in Kenya? My lord, that was an erroneous finding, and we will be asking you to set aside that declaration without much ado. My lord, if you look at the election general regulations on the conduct of elections, they apply to referenda as well, including the statutory forms which are an annex to the elections general regulations. In fact, one of the forms, my lord, is a sample ballot paper for the referendum, Form 30, which is provided for in the elections general regulations. My lord, when you look at the elections registration of voters regulations, you will find statutory forms, like for instance, Form J, which is a form for registration of voters in the diaspora. That particular form applies to voters who wish to vote in the diaspora and contains an express limitation that those voters who wish to participate are only limited to participate in referenda and presidential elections. My lord, consequently, it is an erroneous finding to make that there is that there is no law governing referendum processes. It would have, perhaps the court would have limited its findings to collection, presentation, and verification of signatures. But they went ahead to say that there is no law with legal framework governing the conduct of referendum. My lord, I want on those three elements, collection of endorsement signatures, presentation and verification of signatures, my lord, to associate myself with submissions of counsel who have submitted ahead of me and submit, my lord, that Article 257, Subarticle 4 is self-executing in that regard. It says what it says. It permits no laborious interpretation. It directs promoters of the initiative to submit the bill with the accompanying signatures to the commission, and the commission shall verify that that initiative, it is the initiative which is being verified, is supported by 1 million registered voters. There is no requirement for a forensic analysis of signatures. It is a confirmation that the persons who are said to support the initiative do support the initiative. And it takes many forms, my lord, and we've elaborated in our submissions the mechanisms which are available and which have been tested worldwide for the verification of signatures to support an initiative. It is not, as Mr. Gumba has put it, a process where investigators have to be called in to check whether the signature belongs to that particular person in the sense of an investigation under like a criminal investigation. My lord, allow me to spare my remaining 5 minutes to address you on the administrative procedures which were published by the commission. My lord, under Regulation 100 of the Elections General Regulations, the commission has been donated power by Parliament to publish guidelines in the Gazette. And when the commission is minded, as an EMB, to publish guidelines, they do so. With respect to the guidelines which are alluded to in the judgment of the Superior Court, the Commission did not publish. It was not because for want of power or lapse in its processes that they did not publish. It was deliberate because they are internal rules. They are meant for use by its. You will have occasion, my Lord. I do not have time to take you through those regulations, but you will notice, my Lord, that it is in the nature of a standard operating procedure issued by commissioners to its secretariat. How it landed in this court and became a subject of challenge, my Lord, is you will notice from the record, my Lord, that a request was made by the 82nd respondent, Muhuri. And they asked, do you have any guidelines which you use to verify signatures? And there was a response from the Commission. Oh yes, we have regulations, we have guidelines, our internal guidelines. They took those guidelines together with a letter from the acting commission secretary of the IEBC and challenged it in court. That is how those guidelines have landed before you. But otherwise, they would have been at anniversary towers, not subject of challenge. They are internal to the commission. They are manuals, internal manuals for the commission, standard operating procedures. They have not acquired and were never intended to acquire the status of a statutory instrument within the meaning of the Statutory Instruments Act or Cap 2, Interpretation and General Provisions Act, and consequently, they should not have attracted the order which was, the declaration which was issued under declaration number 17 of the Superior Court's declaratory reliefs. And consequently, my Lord, we will ask you to set aside those declarations. My Lord, allow me to spare the last minute to clarify one issue which was addressed by Attorney General Emeritus with respect to the existence of unamendable clauses and whether the High Court made a finding to that effect. I'll just refer you to the appropriate paragraph in the judgment of the Superior Court. At paragraph 681F, where the court states in no uncertain terms that amendments to Article 89 are unamendable. My Lord, Justice Kiage had posed a question to Attorney General Emeritus whether the Superior Court made such a finding. My Lord, that finding does exist, where the Superior Court stated that amendments to Article 89 are unamendable. That would be all, my Lord. I will donate the last 30 seconds to the court. We ask you. I will ask my lords to allow our appeal. Set aside the judgment of the Superior Court.
Thank you for your generosity, Counsel.
Thank you, my Lord.
Thank you. Now, on that happy note of a donation of time to the court, we have, I think, one appellant remaining only. Is that so, Senior Counsel Mr. Atonyi?
Yes.
And you said you would take 1 hour because you donated 1 hour.
Just 1 hour, perhaps with a bit of concession from the court, a few more minutes.
So you have like 25 or 20, about 20 minutes or so. You can start before we rise it. Okay. All right. I think we break now. We break now. Okay. The view is that we break now because it is about 8 minutes past 1.
Yes.
And then we need to start promptly at 1 hour after this time that we are joining. In the morning we had an unusual occurrence where council were late for quite some time. I think we need to manage our time appropriately. So we are now going to adjourn at 10 minutes past 1. I suggest we reconvene exactly at 10 minutes past 2.
I was going, my lord, to request you, your lordships, to allow us a little bit longer time. This is lunch hour. We come at 2:30. If that is acceptable.
The lunch hour, we agreed and we were starting that it will be 1 hour.
Yeah.
So I respectfully suggest that we still take 1 hour because we have many parties to listen to. So let's come after 1 hour.
Oh, all right.
Just to join us, that was a live feed from the Supreme Court precinct, and in particular the Court of Appeal is having a sitting there in regards to the petition that the High Court, the 5-judge bench, ruled and said that the BBI was indeed unconstitutional. In less than 10 minutes, I'm joined by Counsel Steve Mogaka, who is a constitutional lawyer, perhaps to just have an overview of what has just transpired. In the morning session, we've seen a former AG, Professor Githu, of course, appearing for IEBC in regards to what they had challenged.
Oh yes, and thank you, viewers. This, in legal parlance, we call it, this is the appellant's day in court. And each of them has an onerous task to fault the judgment of the High Court and persuade the Court of Appeal to overturn that judgment. And indeed, yes, today we saw the Attorney General Emeritus, Professor Githu Muigai, for IEBC, trying to persuade the court that whatever decisions the petitioners succeeded in getting from the High Court should be overturned. And he did his work. He did his work, but as we say in law, please, you don't judge the girl's case before listening to the boys. So the boys will also have to come and say their say before the judges retire to say whether what Professor Githu for IEBC was saying amounts to reason enough to overturn the judgment of the 5-judge bench.
Indeed, and the 7-judge bench has quite a task. You do remember there was a High Court decision that had talked about the quorum of IEBC. Now we are saying the same thing is still coming up, and already we had a ruling by Madam Justice Winfrida Onkwani.
Yeah. Indeed, this was a thorn in the flesh of the 5-judge bench because in law we say that a court of concurrent jurisdiction cannot revisit a fellow judge's decision. And true, Justice Okwani had pronounced herself as a sitting judge of the High Court, had pronounced herself on the question of the quorum of IEBC. But as Professor Githu was ably saying, it doesn't matter how many judges of the High Court are sitting. They had no business revisiting Justice Okwani's judgment. But that was his say. let us see what the Court of Appeal says, or what the appellants, rather the respondents' advocates say in response, because they also have their day to deal with that, and they have many things to say. Yeah, because remember, there is a statute that says specifically that the quorum for IEBC is 5 commissioners. Yeah, so the Court of Appeal will have to tell us, was the High Court wrong in enforcing that express provision of the Election Act, saying that quorum for business in IEBC is 5. Yeah, but again, as Professor Gidu was ably saying, where there is a conflict between a parliamentary law and the Constitution, the Constitution prevails. And that is why it was like 3 for IEBC, as said by Justice Okwanyi, is enough. And therefore the High Court overreached in trying to say something different.
And because of the interest of time and away from the appeal, there have been people talking about why can't we perhaps change the election date legally. You're an advocate of the High Court. Is it possible, and how hard is it to change an election date?
No, that is quite curious, and of course that is not before the Court of Appeal today. But in the event, and this is only scenario analysis, in the event that reggae is allowed to resume, then obviously there are consequences to that, because among the items in issue is the existence of additional constituencies. If they are created, the law requires that a constituency must exist for at least 1 year before it qualifies for election. Then we will have to deal with the question, do we then allow these constituencies to feature in the election before they are 1 year old, or do we push forward the election date so that these constituencies qualify? These are issues we will deal with, but as we say, we'll cross the bridge when we get there.
Thank you so much, constitutional lawyer Steve Mogaka. There we were just trying to put in perspective what exactly has transpired in the first session of the morning till some minutes past 1. Thank you did so much, but we are taking a short break, but when we come back, Jackie will be ready with all the day's news.
Antipilo wako ni uchokozi. Songeza kutuliza kwanza.
Hapo TV ni ya baba yenu.
Boss wangu ni yule anayemlipa mshahara baba Upo.
Nakupa dakika moja. Usipofika naenda. Mambo mengine ataka mpangilio, sio kupayuka ovyo. Hebu waunguza huko wewe.
Lakini Kate,
alafu kuwa makini sana ule mke wako. La usivyo tukugarimu. Kunguru mkubwa wewe. Nani kunguru? Wewe.
waendelea nini hapa?
Bwana Motiso, pikipiki yako ndio hii.
Uko shwani yangu.
Hii pikipiki ni, unakumbuka uniekelea the lowest unique bid yako ilikuwa ngapi? 18 shillings. Na unajua kuendesha hii gari?
Kidogo.
Haya, kitoko yako shika helmet, kifungu yako, chomoka na mali yako.
Kujiunga na QuickBid ni rahisi. Enda kwenye M-Pesa, bonyeza paybill, kisha weka business number 4032353. Kwenye account, weka kodi ya bidhaa unayotaka na bid yako ya chini zaidi. Kwa mfano, TV 16. Kisha weka shilingi 20 tu kama idadi yako. Weka bid yako pia kwenye www.quickbid.co.ke. Kumbuka, bid ya chini zaidi ya kipekee ndio hununua. QuickBid, bidhaa bora kwa bei ya chini.
counsel and his team. What happened? Put on the microphone.
My Lord, Professor is taking a bathroom break. He'll be with us in
Sorry, we can't hear you, counsel.
My Lords, my name is Miss Muigai. I hold brief for Professor Given Muigai.
Yes.
He is having a short bathroom break. He'll be here in 10 minutes.
He's having a?
He's taking a call, an urgent call. He'll be here in 10 minutes.